The Clerk will now proceed to read the orders of the day.
Protection from Sex-based Harassment in Public Bill, as amended in Public Bill Committee, to be considered.
Now.
Before we get on to proceedings, I remind members of the differences between report stage and third reading. The scope of the report stage debate is the amendments I have selected. The scope of the third reading debate to follow will be the whole bill as it stands after report stage. Members may wish to consider these points and then decide at which stage or stages they want to catch my eye to make sure that their speeches are relevant to the stage at which we are considering the bill. So, we will start with new clause 1, with which it will be convenient to consider all the other amendments. Greg Clark to move new clause 1.
Thank you very much indeed, Madam Deputy Speaker, and thank you for your guidance on our proceedings for this morning. And I beg to move that new clause 1, in my name and the name of honourable members from across this House, be added to the bill. And in line with your advice, I will address my new clause and the amendments in my name specifically, and also touch on the amendments of my honourable friend, the member for Christchurch. And so I will not rehearse the reasons for the bill. We've had a substantial debate at second reading and at committee stage, and I hope that it may be possible to say more at third reading. New clause 1 would require the Secretary of State to issue guidance to the police about the new offence that is proposed in this bill, and that guidance must include, but is not limited to, guidance on the defence of reasonable conduct that is already contained in the Public Order Act. Now, Madam Deputy Speaker, during our debate in committee, some members were understandably concerned that the perpetrator of an act of deliberate harassment of a person on the grounds of their sex could escape the consequences of their actions by asserting that they thought that their behaviour was reasonable. And some members thought that in particular the police risked being put off from taking seriously the offence because of that potential defence. Now, in fact, in the Public Order Act, reasonableness is not in the eye of the accused. Simply saying that behaviour that was intentionally designed to cause alarm or distress was reasonable does not, if I can coin a phrase, provide a get-out-of-jail card. But having clear guidance on this point will make sure that the matter is crystal clear to the police and all of the authorities. The proposed requirement for statutory guidance, therefore, provides that, but is not limited to that. And so the guidance can include other matters, should it prove desirable to contain them in the future. Now, Madam Deputy Speaker, the guidance is addressed to the police, as is obvious from the terms of the new clause, but in practice, its use is wider than that, including the Crown Prosecution Service. And that's because once statutory guidance is issued, in practice, it's taken by all parties to be authoritative. Indeed, there's no point in having separate guidance for the police, separate guidance to the CPS, separate guidance to any other body. And this is far from the only occasion in which guidance is formally issued and addressed to one particular audience, rather than being proliferated to multiple actors. For example, statutory guidance within the Stalking Protection Act 2019 is formally issued to the police, but was drawn up in consultation with other statutory partners, including the Crown Prosecution Service. And I envisage and hope that the Minister will be able to confirm that the same approach will be taken in this case, and that the CPS would be involved in the drawing up of the guidance to which my new clause refers. So it seems to me, Madam Deputy Speaker, reflecting on the debate that we had in committee, that an amendment on the face of the bill that guidance must be issued and that must include, inter alia, statutory requirements on the interpretation of reasonable conduct is a pragmatic and practical way of responding to the points that were made in debate. and I'm delighted that the amendment has attracted widespread support, including that of the government, whose assistance in drafting I gratefully acknowledge.
Will my right honourable friend be away?
With pleasure.
Can my right honourable friend say how long he expects it to be for this guidance to be produced? Because I have in mind that the guidance requested last year on the draft code of practice on the recording and retention of personal data on non-crime hate incidents, that took more than 1 year to produce. Does he envisage a similarly long period? And can I also ask him to what extent he expects this House to be able to have a say on the content of this guidance?
Well, I would say to my honourable friend, I would be very dismayed indeed if it took a year to draw up such guidance, and that is a cautionary warning that he gives. I hope it might be possible when the Minister responds to the debate that he may give an undertaking to produce the guidance with dispatch. Having said a few moments ago that I think it's right and appropriate that the guidance is drawn up in conjunction with the CPS, who will also, as I've just said, have regard to it, that will take some time, but I would hope that would be a matter of weeks rather than a large number of months. But the Minister, he and I are experienced in office, and we know that only the Minister can give that assurance as to how long it would take. But I'm delighted that he shares my impatience to get on with that. Can I turn to the amendments in my honourable friend's name?
I'm grateful. And what about the ability of this House to be able to comment on the guidance when it's produced or in preparation of its production?
Well, as my honourable friend knows, the nature of guidance is that it is issued by the government of the day. It is not a statutory instrument, and we're not proposing that it should be a statutory instrument. But again, I see no reason why I think it would be desirable for the guidance to be shared not just with this House, but in public, so that guidance that is important should enjoy the confidence and the wisdom of those that are intending to use it.
So finally on that point, would my right honourable friend envisage that the guidance first be produced in draft form so that there's an opportunity for people to be consulted publicly on it?
Well, again, I think that's a matter for the Minister, but I can say to him that I would be not only content with that, but I think it would be a desirable route to take on that. So let me turn to the amendments in the name of my honourable friend. And let me say from the outset, he's absolutely right in seeking to ensure that legislation in this House is properly scrutinised and debated, and the points that he's made, just including the ones that he's just made, are absolutely pertinent and valuable. And as I hope he might expect, I've studied the amendments very carefully this week since he tabled them. So let me deal with them in turn. Amendments 3 to 5, in my honourable friend's name, prefer the words due to over because of in the bill. Now, precise language is important, and he and I think, share that view. But I don't think that this preference on his part signifies any difference in interpretation. Because of, the expression because of, is the expression extensively used in other existing legislation on the statute book. For example, the Consumer Rights Act in section 66(4) refers to circumstances in which someone suffers loss or damage, and I quote, because of the dangerous state of a premises, because of rather than due to. And perhaps with more immediate relevance to our discussions this morning, the Equality Act uses because of rather than due to. For example, Schedule 11, paragraph 3(5) of that Act on school admissions refers to circumstances in which a school, and I quote, does not admit a person as a pupil because of the person's sex, rather than due to the person's sex. Now, it may well be that my honourable friend's use of language is more elegant than that contained in the laws already on the statute book. But I hope that he will agree with me that there is some virtue in linguistic consistency, in the law, and that is the reason behind that choice of words. Now, my honourable friend's amendment number 4 clarifies that it does not matter if A, specified in the bill, A being the perpetrator of the offence in question, is a man or a woman. And although a majority of reports of public sex-based harassment have been by men towards women, the bill applies totally equally to both sexes, and at no point does the bill mention any one sex. There is no ambiguity in the bill on that point. But if my honourable friend is concerned that in practice this may not be clearly understood, for example, by the police, it may be a candidate for inclusion in that statutory guidance to which we've already referred. And as he will recall, the guidance specifies the interpretation of reasonable conduct, but is not limited to that. And so if there turns out to be, perhaps after taking soundings with the public, some ambiguity in people's minds, if not on the face of the bill, there is the opportunity to address that. Amendments 2 and 6, in my honourable friend's name, would introduce a concept of subsidiarity and primacy, if I can call them that. In other words, an offence would be committed only if the sex-based harassment was the primary motivation or aspect of the behaviour, rather than one of a number of aspects. Now, I completely understand the point that my honourable friend is putting forward. But I would say two things in response. First of all, one of the purposes of this bill is to bring in line harassment on the grounds of sex with the existing law as it affects other protected characteristics, such as, for example, race. And so to take that as an example, to be guilty of the aggravated offence of public harassment on the grounds of race does not require the racial element to be the primary element of a torrent of abuse that one person might direct at another. Nor is public racial harassment defensible on the grounds that racist harassment was merely a secondary aspect of the behaviour in question. And indeed, not only is there the argument of consistency that this bill seeks to address, but in this case, I think it is right that it is framed in that way, because racist abuse shouldn't happen at all, and the law should be clear on that, and I think that applies equally to harassment on the grounds of someone's sex. So for reasons of consistency with the established law elsewhere, and in my view what is right, I don't believe we should introduce a special category of primacy, a filter for primacy on the grounds of sex that doesn't apply already to race and the other offences that already have this protection. Now, Amendments 7 and 6 in my honourable friend's name would delete references to, and I quote, or presumed sex. Now, the current treatment in the bill as drafted is again drafted to be consistent with the law as it applies in other contexts, and in particularly to protected characteristics. So, for example, to use the example of racial harassment that I mentioned, Section 28 of the Crime and Disorder Act, 1998, makes it clear that an offence is racially aggravated if the offender demonstrates hostility, and I quote, based on the victim's membership or presumed membership of a racial group. It's not always possible, with 100% accuracy, to determine a person's race or sex in a public place. Indeed, Shakespeare would have been robbed of many a dramatic plotline were it otherwise. But that does not mean that it should be acceptable intentionally to hurl abuse at someone who turns out not to be of the sex that was assumed, any more than it would be acceptable to scream racial abuse at someone in public who turned out not to be of the race that the perpetrator presumed them to be. Therefore, again, for reasons of consistency with the existing law and for reasons of justice, I think the drafting of the bill has it right. Finally, my honourable friend in Amendment 9, presaged in his earlier intervention, seeks to specify a commencement date of the 1st of August this year for this legislation to come into effect. And I am very grateful to my honourable friend's impatience to get on with changing the law, and he's quite right in all seriousness that if Parliament passes legislation, then it should, that signals the intention of Parliament that the law should change, and the government should not then act as a brake on the law being changed in practice. Indeed, it would be unconscionable for it to sit on the statute book uncommenced and therefore unusable to the police and courts, who, those that might be watching these proceedings or reports of it, will have a legitimate expectation that if this bill passes, that the law has been changed or will change shortly. However, Madam Deputy Speaker, should this bill be approved by this House today, as all colleagues know, it would then need to go to the House of Lords, whose procedures and timings are not always clear to at least this member of this House. And if my new clause requiring statutory guidance to be issued is inserted by the House, as we have discussed a few moments ago, that will take some time, especially if we provide an opportunity to take soundings on it before it is adopted. And so I fear that the 1st of August may be a little too specific and early to be on the face of the bill for when commencement must be made by. But I don't want to in any way separate myself from the motivation of my honourable friend in this, quite the reverse. And should this bill attract the favour of the House and the other place, I hope that instead my honourable friend will join me in pressing the government today to commit in seriousness to commencing the legislation as soon as is practically possible. And should that commitment that I hope might be given turn out not to be enacted in practice, I hope that he will bolster my efforts, given his considerable experience and indeed success in this, to join me in harrying the government at every opportunity and do so relentlessly until this legislation is commenced. In conclusion, Madam Deputy Speaker, I'm very grateful to my honourable friend for his thoughtful and apposite amendments. I hope he can tell that I've seriously considered their effect, and I think in no case am I antipathetic to the quite reasonable questions that he raises about them. But I do think that they have answers in the current drafting of the bill with the amendment that I am moving today. So I hope that at the end of this debate, he'll feel able to withdraw them and to, should circumstances arrive, join me in continuing a campaign for great dispatch on the part of the government. So, Madam Deputy Speaker, I beg to move the amendment and the new clause in my name.
New clause 1, guidance.
The question is that new clause 1 be read a second time. Stella Creasy.
Thank you, Madam Deputy Speaker. I rise as the person who tabled the original amendments in committee that I think have prefigured new clause 1 to recognise this as the best of Parliament, but actually when we come together to write legislation that we believe will make a positive and constructive difference to people, listening to each other's concerns, recognising the positive process that scrutiny can play, can bear fruits that we can all support. So I want to welcome and support new clause 1 as that recognition that there was a concern and an issue with the concept of reasonableness at the heart of public order offences. Let me just clarify what I mean by that. Because this legislation is about harassment, other forms of harassment legislation have always had within them a test that somebody's behaviour cannot be considered reasonable if a general opinion would be that their behaviour was unreasonable. In layman's terms, when it comes to the harassment that we're talking about, that if somebody were being followed down the street and shouted at, particularly about their sex or their presumed sex, even if that person were to claim it were reasonable, a court, a magistrate should be able to say that is patently not, and you should not be able to evade prosecution under this legislation accordingly. However, because this was originally based on public order offences, those distinctions about whether somebody ought to know their behaviour was unreasonable were not contained within the public order legislation. It is very welcome to me, therefore, that the government has listened and agreed to put out guidance that will consider this point, and I hope in setting out what I believe that guidance should cover, that will be a helpful guide to the government and perhaps answer the genuine queries I know from the member for Christchurch about whether there could be involvement in it. Because for many of us, getting this right speaks to the heart of how this legislation will be the effective freedom that we hope it will deliver, particularly for women, but not exclusively for women, because we know it is women who are overwhelmingly reporting the kind of instances that we're talking about in this legislation. But one of the challenges will be that initial decision whether or not somebody has committed an offence. And many of us are extremely used to the idea that it is our reaction to somebody's provocation rather than their provocation that is the challenge here. So what New Clause 1 will do, I hope, is recognise that in consistency with other forms of harassment legislation, a defendant who argues that their behaviour is reasonable should not be a reason not to proceed with a charge. I want to be very clear about this because I could understand why people would be concerned. Nobody is suggesting that the reasonableness defence should not remain. What we are arguing is that that should be a matter for the courts or the magistrates to decide whether behaviour was reasonable rather than the defendant. So in setting out that guidance, I hope the government will give weight to the idea that the presentation of a reasonableness defence, which we know happens quite frequently in harassment cases, but we recognise hasn't necessarily happened with public order offences to date, will be set out, that it should not be a matter that deters the CPS or indeed deters the police from seeking to proceed with a prosecution. And in that sense, it would be consistent with the guidance, for example, on the Serious and Organised Crime and Police Act 2005 or the Protection from Harassment Act 1997. Can I also then, in setting that out, agree with the member for Tunbridge Wells about some of the other amendments that have been put forward today about the importance of consistency in the law, and just add my support to the argument that he has made about retaining presumed sex within the legislation. Because the most important thing about this legislation is that we turn the lens from the behaviour of victims and behaviour of women in particular, because we know, although this legislation covers both men and women and indeed covers both male and female perpetrators, it is women who will particularly benefit from clarifying that street-based harassment is unacceptable and is illegal already, and therefore should carry a higher penalty if it is targeted in this way. That too often it has been the behaviour of the victim that has been called into question in deciding whether to prosecute. And so what this legislation does, and why it is important that it is written in this way, is to turn our attention back to the perpetrator. Were we to have such loopholes, whether it's around reasonableness, whether it's about the status of the victim, we could inadvertently undermine the capacity of the police and the CPS to be able to secure those outcomes. So I recognise the attempt of the member from Christchurch to test the legislation, and I hope if he'd had read the scrutiny that was given to this legislation in committee, he would have appreciated that too, because that's where New Clause 1 has derived from. But I hope he will understand where many of us feel that this change and those changes would actually undermine this legislation, because it would mean that it would not be as clear that our sole concern is on those people who harass and intimidate and abuse other people in public, and who are doing it because they are focused on the sex or the presumed sex of the person in question who is the victim. And the important thing that we want to send by passing this legislation is that those existing crimes should not be diminished, they should not be ignored, they should not be seen as part of everyday life, and that we should address them. So it's all I wanted to say, Madam Deputy Speaker, as to say the person who originally came up with the amendment that I think has led to New Clause 1, and to recognise this cross-party working in wanting to get this legislation right. And I hope that those people who had concerns about whether it was New Clause 1 or indeed the other drafting of the legislation will see the benefit in having had these discussions, but also the outcome in the legislation as it is now drafted will indeed benefit many of our constituents as a result.
Sir Christopher Chope.
Madam Deputy Speaker, it's a pleasure to follow the Honourable Lady, who I know takes a great interest in this particular subject. And I'm delighted that she has included in her remarks a reference to the fact that this legislation applies to men who are victims equally as it applies to women who are victims. And one of my concerns when looking at the report of what has happened in committee was that I don't think there was even a mention of men and boys involved in being the victims, and I wanted therefore to ensure that emphasis was given to the fact that this bill applies to men and women equally, and I was grateful to my right honourable friend for emphasising that point and saying that perhaps if need be this could be included in the guidance which is produced for prosecutors. Can I just emphasise that the extent to which men are being sexually harassed is significant. And I've got here a report from the Diversity Dashboard, which makes clear that sexual harassment in the workplace is widespread and that women suffer the most. But it also makes clear that a significant percentage of men are also victims of sexual harassment. And according to the Nursing Times, very many people don't report to their employer that they've been harassed, and only 17% of sexually harassed male nurses report it to their employer. Overall, female nurses are more frequent subjects of sexual harassment, but sexual harassment statistics by gender tell us that men aren't spared either, and indeed 51% of the male respondents to the Nursing Times survey said that they had been sexually harassed. That's a very high percentage. And research shows that when a man suffers a sexual assault in the workplace, a woman is a perpetrator in 76% of the cases. And it's also apparently the Nursing Times established that it's very, and I quote, it's worrying and insensitive that such behaviour is seen as a joke when it involves male victims. And that's why, although men are overwhelmingly responsible for sexual harassment against women, we also need to take into account that men are on the receiving end of this as well. And the reason I think this is very important at the moment is because of a growing belief among experts, including those who are in the professions relating to psychiatry and psychology, about the impact of sexual politics, as it's called, on young men. And you may, Madam Deputy Speaker, have seen the article in a recent copy of the Spectator magazine by Gus Carter, in which he refers to masculinity having been in crisis, and that it is now in crisis, and that the polling company YouGov has found that just 8% of people have positive views of white men in their 20s, by far the lowest of any ethnicity or age group, and that males are routinely presented as inherently dangerous, aggressive and animalistic, incapable of controlling their own instincts. And he refers to the fact that on public transport, government adverts announce that staring is sexual harassment. And he says, us blokes can't even be trusted to use our eyes properly. Madam Deputy Speaker, I think this is a very serious aspect of this whole debate around harassment, and as I prefer to put it, basically common decency, standards of behaviour, and politesse. But the consequence of the, in a sense, the sexualisation of this harassment is that it's having an adverse effect upon young males, and teenage boys are being routinely disciplined by their schools in circumstances where their female counterparts are not. And that there's one teacher a former female teacher who left the profession last year, is quoted in this article saying, "Boys are now seen as potential perverts. There was this obsession with the victimization of women. I thought we'd been getting somewhere with sex and relationships, teaching the children to treat people with respect. But that has been totally set back." I won't go into all the other points that are made, but one point I think is relevant to this debate, and that is there seems to be an inability to hold two notions in our heads: that sexual assault is bad, and that treating men as inherent sex pests is also bad. And a reasonable worry about assault appears to have morphed into an institutional misandry. There is a lack of recognition that, as with all crimes, the proportion of perpetrators is vanishingly small. The awful behaviour of a few is leading to the mistreatment of all. And the consequences of all this, and unless we're extremely careful with the language that we use, Madam Deputy Speaker, is that the situation which is already bad is in relation to the mental health issues of boys and young men is going to get even worse. Since 2017, the NHS has found that the proportion of boys with probable mental health issues has increased by more than 50%, and now to nearly 1 in 5. The suicide rate for boys aged 15 to 19 has more than doubled over the past decade. And the child psychologist, Julie Evans, has said that she thinks the pendulum now has swung too far in the other direction. Boys came out of lockdown into this slightly hysterical atmosphere of don't touch, that's inappropriate, that's assault. And they're being treated as guilty until proven innocent. And this article, which I think is a very telling article, goes on then to say, well, what are we going to do about this? Are we going to recognise that young men aged 18 to 24 are more likely to be unemployed, significantly more likely to be unemployed than similar age group for women, and that women are outperforming men in university, and you've got the problem of workless men living with their parents and almost being discouraged or intimidated into not going out onto the street, not only not finding jobs, but not finding girlfriends, and so on. There's a really serious problem developing for us, and that's why I thought it would be important to put down this amendment to try and put that balance right. And I'm grateful to my right honourable friend for recognising the significance of that, and even the honourable, I say even the honourable lady opposite seems to accept this. And I hope that when she makes remarks in the future on this subject, she always emphasises that this is not just one particular group of victims, but people in general of both sexes. Turning to some of the other amendments that I put down, which were designed to develop a debate, Madam Deputy Speaker, and I think we're having that debate. Dealing first of all with the time scale for this, and the fear that the guidance will be much delayed. I'm not sure that actually the requirement to produce the guidance is necessarily a reason why the bill couldn't come in, the act couldn't come into law. The guidance would follow, because this offence would still be created, and the guidance would follow, and it's not conditional upon the guidance being produced first. So I don't think that's really an adequate reason on the part of the government for not accepting a specific date of implementation. My right honourable friend generously says, well, I try to keep an eye on some of these things, and one of the reasons that I put a specific date into clause 2 is because I had a similar experience in relation to the bill brought before this place by my right honourable friend, the member for East Yorkshire, on the abuse of parking rules by rogue parking companies. And he brought forward this bill, and I suggested that the guidance that was going to follow from it have to be delivered within a particular specified period of time, and that if it wasn't, the legislation wouldn't take effect. And I'm afraid to say that as of today, and I think we're talking about 2 years back, the legislation has still not actually come into effect. And if the amendment that I put down had actually been accepted by my right honourable friend, who was sympathetic to it, but was persuaded by the government to encourage me to withdraw it in order to protect his bill. I just quote that as a current example of the problem where we leave it to the government to decide when and if such legislation is actually going to come into effect. And I know that at the moment, and perhaps my right honourable friend in responding to this will deal with the issue around prisons and the number of prisoners that there are. One can understand that the government might be nervous about the fact that one of the consequences of this legislation might be that more people would be sent to prison. Certainly that was one of the objections put forward by a previous government to suggestions that we should introduce more severe more severe penalties for people who were convicted of causing death by dangerous driving, and the argument was put that this was going to result in a particular number of extra prison places having to be used. But I hope that the Minister in responding will say that the issue about the number of people in prison is not relevant to this debate, because surely what we need in our legal system is that law should take its course and people should not be excluded from punishment in prison if that is what is merited, just because we don't seem to have got enough room in the prisons. If we haven't got enough room in the prisons, we either need to remove from those prisons some of the people who are still on indeterminate sentences, which I think is pretty unjust, or we need to build some more prisons. But that's why I think it's important to put a fixed date into the bill, and I've chosen arbitrarily the 1st of August 2023, but actually it's not that arbitrary, because I was assuming that the normal rule would be 2 months after royal assent, and that this bill, all other things being equal, would get through the other place before the end of that period. Turning to the other amendments that I've put down, the issue about because of or due to, that is, I concede we can dance on the head of a pin in relation to that. But I'm grateful to my right honourable friend for having looked at that. In relation to the amendments about primacy, see, my understanding when I first looked at the bill was that clause 1 actually meant that for the purposes clause 1, a person is guilty of an offence under this section if A commits an offence under section 4A and A carried out the conduct referred to in section 4A because of the relevant person's sex or presumed sex. And I assumed that was would be the sole or reason for that behaviour. And indeed, in discussing it with my right honourable friend, I thought that was his own understanding of his bill, that there wouldn't be any other subsidiary reasons or reasons which would be taken into account. But then I looked at the next clause, and it says that subsection 3A, it says for the purposes of subsection 1B, the one to which I've just referred, it doesn't matter whether or not A also carried out the conduct referred to because of any other factor. And I couldn't understand why that any other factor had been introduced, because it seemed to me to be rather redundant, and it undermined the contention which my right honourable friend has said he had when drafting this bill, that it should be that it should be clear that this was the primary, if not the sole, reason for the conduct referred to, and that my right honourable friend has used a slightly different explanation today as to why he's unhappy with my amendments, and is citing various precedents from other acts and claiming consistency. But I'd be grateful to the Minister when he responds to this debate if he can spell out whether he does accept that the conduct carried out because of the relevant person's sex must be the main reason, otherwise there will not be an offence being committed under the provisions of this bill. And if he's able to spell that out, and perhaps it will be repeated in the guidance, then I will go home as a happy bunny, relatively speaking, Madam Deputy Speaker. And actually on that note, I have to say that I think as I'm speaking here, at this very moment, the other place is debating the third reading of my private member's bill on mobile homes pitch fees and changing the rules from RPI to CPI. And so I hope that I will certainly be able to go home a happy bunny on the basis of that getting a third reading in the other place. And I'm most grateful to my my noble friend Lord Udney Lister for taking it through that House. But that's by way of a bit of an aside, Madam Deputy Speaker. Can I just say that the issue then comes as to I put in Amendment 7 and Amendment 8 talking about sex or presumed sex. It seems to me that if you are in the business, and I hope that not many people are, of harassing people on the basis of their sex, and they think that they're harassing a man or they're harassing a woman, and then it turns out that the person they're harassing is not a man, but it turns out to be a woman, or vice versa, then it seems to me that is the amount of alarm or distress that's going to be caused by the person on the receiving end is going to be significantly reduced if the person on the receiving end is not the person of the sex that was intended by the person who was making those harassing. So I'll give way to my right honourable friend first.
I'm very grateful to my honourable friend, and I don't seek to quarrel with him, but in the analogous situation in which a person with brown skin, relatively dark skin, were the subject of a humiliating torrent of racial abuse in the streets, but actually happened to have a skin of a relatively dark pigment, but was not a member of a racial group. I don't think that would diminish the impact and the offence intended by the person, and surely the same would apply in this case, and actually the person on the receiving end would feel humiliation, and the perpetrator would have exactly the same intention.
Well, with the greatest respect to my right honourable friend, I think he's conflating two dissimilar situations, because in the situation he's describing, that is already an aggravated offence. And what we're talking about here is offences which are not aggravated. Indeed, it's because they are not regarded as aggravated offences and thereby qualifying for greater punishments. That's why this bill has been brought forward. And so I think it's a mistake to try and equate a situation where it already is an aggravated offence with the situation which we've got on the face of this bill. Because if you are harassing or making remarks to somebody, and you, in the mistaken belief that the person you're trying to insult is a woman, and it turns out that the person's a man, and then it seems to me that that's a mistake, and that's going to probably it's still going to enable you to be convicted of a public order offence, but it won't be a public order offence because your behaviour is because of that person's sex. It's semantics. I'm prepared to concede, but that is why I brought forward that particular amendment. And so, Madam, yes, of course I will. Yes.
I'm very grateful to the Honourable Gentleman for giving way, and in respect of his comments prior to the intervention of my honourable friend from Tunbridge Wells, was he saying that misgendering somebody was going to cause less offence to them as opposed to greater offence? Because to my mind, any sexual-based harassment, whether it be misgendered or correctly gendered, is still going to cause offence.
Well, I'm trying to avoid, and I have avoided up till now, Madam Deputy Speaker, getting into the debate about the difference between sex and gender. And so I'm not going to rise to the bait that my honourable friend has given me to try and develop arguments around that. This bill, I think commendably, is specific to sex, and it leaves out gender. And so I'm going to leave it at that, if that's all right with my honourable friend. But I think this brings me to the conclusion of my remarks. I'm not going to, at this stage, say what my intentions are in relation to these amendments until I've heard from the Minister, which I hope, Madam Deputy Speaker, you will think is a reasonable approach to take.
Shadow Secretary of State, Annalise Dodds.
Thank you very much, Madam Deputy Speaker. And I want to say, first of all, how pleased I am to see this bill finally making its way through the House today. And I want to thank all of the campaigners who've worked tirelessly on this issue. Obviously, the Right Honourable Member for Tunbridge Wells and all of his engagement, that of the civil servants, of course, who've also been working with him on this, and indeed my friend for Walthamstow and the many other members in this House who have contributed to discussions on this subject for such a long time. And as we near the end of Women's History Month 2023, this bill is a welcome step in the right direction. And perhaps, if I may, Madam Deputy Speaker, I would like to pull us back to the main subject at issue, which is around public sexual harassment. It does remain a major problem in our society. Plan International UK found 3/4 of girls and young women aged 12 to 21 experienced a form of sexual harassment in a public space in their lifetime. Those numbers actually increase for disabled women and girls from a Black, Asian or another minority ethnic background. And actually the impact of this harassment is shocking, and I think it perhaps is worth just reminding the House about this as we discuss this bill. In 2020, the Girl Guides found out that 80% of girls and young women feel unsafe when they're out on their own, increasing to 96% of young women aged 17 and 18. Madam Deputy Speaker.
Order. Just a reminder that at this stage we are discussing this amendment. There'll be, I'm sure, a very good opportunity at third reading for the wider issues. But at this point, we're just doing the report stage. If the Honourable Lady prefers to wait to third reading, absolutely fine.
In that case, Madam Deputy Speaker, I would just say the reason why I mentioned those points was in relation to the new clause that has been introduced and the other amendments. I believe that the Right Honourable Member for Tunbridge Wells has set out very clearly the rationale, as has indeed my honourable friend for Waltham, so spelling out why, yes, we do require to have guidance. We all hope it will come speedily, but also why it is actually important this legislation is consistent with other acts in this area, and therefore I do hope that the House will bear those remarks in mind when deciding how to vote. Thank you.
Minister Crisfield.
Thank you, Madam Deputy Speaker. It's a great pleasure to speak to these amendments before the House at this report stage. Let me start by saying that I'm very grateful to my right honourable friend, the member for Tunbridge Wells, for his new Clause 1 and Amendment 1. I'm happy, Madam Deputy Speaker, to take this opportunity to formally confirm that the Government does support those amendments. As my right honourable friend has set out, this clause would require ministers to publish statutory guidance for all police forces to which those forces would have to have regard. That guidance would in particular need to include material about the reasonable conduct defence, which has been the focus of so much discussion. I know that there has been some concern expressed, I think, by the member for Walthamstow and others that a subjective interpretation of the reasonable conduct defence might be adopted by defendants in an attempt to repudiate responsibility for their actions or to avoid conviction. It is the view of the Government that what constitutes reasonable conduct can be defined objectively with regard to their conduct and without needing to have regard to somebody's internal thought processes. However, we do agree that in order to be completely clear about this point and to remove any ambiguity, this guidance would be valuable, which is why we're happy to support the right honourable member for Tunbridge Wells new Clause 1 and Amendment 1. It would of course be possible for many other people to refer to this guidance besides just the police, including, of course, the Crown Prosecution Service, who we would expect to be operating on the same basis as the police when they prosecute these offences. Just to respond to a very reasonable question, quite rightly asked by the honourable member for Christchurch, we do, of course, want to get this done as quickly as possible. I certainly would not want or expect this to take anything like as long as a year, which honourable member referred to in his speech in a different context. I would hope this can be accomplished in a matter of months. Now, the honourable member for Christchurch also said that this is something that should be subject to input and scrutiny. I'm sure the member for Walthamstow would agree with that, to make sure that it's constructed in a way that is proportionate and reasonable. And so I think that I would therefore expect that opportunities will be provided to interested parties to provide that comment, and I'll give consideration to whether or not we should have a formal consultation process on the guidance, but of course we should be mindful that if we do that it will obviously introduce additional delay. But given that point has been essentially raised, we'll give it thought and we'll strike the right balance between getting this done quickly, which everybody wants, but also making sure interested parties, both in Parliament and of course outside Parliament, have an opportunity to input into the construction of this guidance. I'm very grateful to the honourable member for Tunbridge Wells for tabling the amendment, and for other members, the members particularly for Walthamstow and Christchurch, for offering their comments on it. Of course, I give way.
I'm grateful for my right honourable friend, but obviously, would it not be normal to produce the draft guidance and then consult on it, rather than expect the government to come up with the perfect solution after it's received representations in general? I do strongly urge my right honourable friend to take the approach of having draft guidance first.
Well, it is of course occasionally possible for the government to come up with something perfect straight away, but I do accept that doesn't always universally occur. And so the process that the honourable member for Christchurch just set out, that is that the government might publish a draft and invite comments on that, either informally or via a formal consultation, does seem to me to be a sensible way of arranging matters.
I thank the Minister for giving way. Actually, one of the concerns behind a lot of this is about consistency in the law, because we know with other forms of harassment legislation, it is already written in about how reasonableness is defined. And I wonder if I could just invite him to perhaps consider whether actually what the important thing to do is not to come up with a whole new set of guidelines, but simply to clarify the consistency in how we expect courts and how we expect juries to consider this concept of when somebody claims, I thought my behaviour was reasonable, the law says, well, you ought to have known in other forms of harassment legislation. So actually, this isn't about a new piece of guidance, it's about clarifying it so that we don't inadvertently damage the ways in which our courts can work. For example, I'm looking at the CPS guidance for the Serious Crime Act, and it talks about defendants ought to know their course of conduct, again with oblique directions that judges can give. There's plenty of guidance out there. We really just need to compile it into one document, don't we?
Well, I completely agree with what the Honourable Lady for Member for Walthamstow has just said. There is existing guidance in other areas and existing practice which quite rightly clarifies or confirms that someone's, when assessing reasonableness, that includes what somebody ought to have known, and you can of course draw inferences from their behaviour. So she's quite right to point to that existing guidance and practice, and I completely agree that we should be consistent with that, and it would, I'm sure, looking at that would help draw a draft up in a quick manner. So I think the approach that a combination of the member for Walthamstow and Christchurch have both suggested will lead us to the right answer very quickly, and enable us to then quickly just sort of publish something, a draft, and get views on that, as the member for Christchurch suggested. So it sounds to me like there is a rapid, sensible, pragmatic and consistent way forward in this area. Let me turn now, if I may, Madam Deputy Speaker, to the amendments moved by my honourable friend, the member for Christchurch. Let me start on the topic of his good humour. I've been informed by the government whips, a source of unimpeachable reliability, obviously, that the second reading of his private member's bill in the other place regarding park pitch fees has been successfully passed by the other place, unopposed, Madam Deputy Speaker. So I hope that provides an early boost to my honourable friend's good humour. One point arose in his speech, which doesn't relate directly to an amendment, but I think is important, so I do want to just respond to it. And it's something I've noticed as well, adverts on London Underground tubes referring to people's behaviour in terms of where they look. And he said that was produced by the government. And just for the sake of clarity, those advertisements are in fact produced by the Mayor of London in his capacity as the head of transport for London. Now, turning to the various amendments tabled by an honourable member, my honourable friend, the member for Tunbridge Wells, has, as the House will have heard, given these, as one would expect, very close and careful consideration, as have colleagues in the Home Office. We understand completely that the member for Christchurch has made these amendments or proposed these amendments after a great deal of consideration, which we've taken very seriously indeed. So I'd like to go through them one by one. First of all, Amendments 2 and 6 would require the other person's sex, the victim's sex, to have been the principal motivation for the defendant's behaviour. As my right honourable friend, the member for Tunbridge Wells, has set out, in drafting the legislation in the way that he has, we are following precedent. And I think it is best that where possible, as the member for Walthamstow said a moment ago, that we do try and be consistent in the way that we legislate. I think if there is any component of the motivation for the defendant's behaviour which is concerned with the sex of the victim, that is in itself of great concern. It may not be the principal component in some cases. It may simply be a component. It may even be a subsidiary component, but that is nonetheless serious. The intent of the House here is to protect people from sex-based harassment, and so whether or not the sex-based component is the principal component or a subsidiary component, it strikes me that nonetheless that seriousness remains, and that to translate the House's intention into legislation, I think our feeling on balance, having considered it very carefully and of course discussed it with the member in charge, the right honourable member for Tunbridge Wells, we do feel the drafting as it was best achieves the intent and is also consistent with the rest of the statute book. Amendments 3 and 5, which substitute the words or seek to replace the words because of, I think my honourable friend, the member for Tunbridge Wells, has once again explained or set out to the House the fact that the use of these words because of appear in a number of other contexts, in other pieces of legislation. And although, as he said, the member for Christchurch's command of the English language and the elegance of expression cannot be disputed, there is again a great benefit to consistency with other pieces of legislation, and so we feel following precedent and maintaining that consistency is a good idea. Let me turn now to Amendments 7 and 8, which would restrict the new offence only to cases where, if passed, the harassing behaviour is done because of a victim's actual sex and not what the defendant presumes the victim's sex to be. And I agree with the Honourable Member for Christchurch. Getting into wider discussions about the distinction between sex and gender would probably not be helpful in the context of this debate this afternoon or this morning. So we're considering here a circumstance where somebody harasses somebody else in the erroneous belief that their gender is the opposite to what it actually is. And I think really what matters here is the intent to cause sex-based distress and harassment. And even if the perpetrator or the alleged perpetrator was mistaken in their assumption about the sex of the victim or the purported victim, the complainant, I don't think that minimises or mitigates the seriousness of the act being undertaken. The intention is there, the act has been undertaken. The fact that the victim or the complainant may not be what the perpetrator thinks, I don't think mitigates or minimises the seriousness of the act being undertaken. Amendment 4 would... before I turn to Amendment 4, there was a question, Madam Deputy Speaker, that arose in the course of the Honourable Member for Christchurch's speech that I meant to address at the beginning of my remarks, but didn't do so I'd like to turn to it now. I agree with him, the Member for Christchurch, Honourable Member for Christchurch, that in framing new legislation, concerns about prison capacity should not, as he said, constrain what the House may do. It is, of course, incumbent for Parliament will legislate, it will set out criminal offences, the police will investigate, the Crown Prosecution Service will prosecute, the courts will, if appropriate, convict. It is then up to the government to make sure that adequate prison capacity is available. And to that end, I know that my right honourable friend, the Lord Chancellor and Secretary of State for Justice, is engaged in a substantial prison building programme. So I will just 1 second. So I agree with the Honourable Member for Christchurch that prison capacity constraints or availability should not in any way fetter the House as it considers legislation. Of course, I give way.
The Honourable Gentleman is making some very good points. The only exception, I think the Mayor of London, Sadiq Khan, has had a good record on this general area. But in terms of prison population, isn't it about time we did something about the 1,000 young people convicted on a joint enterprise that could open up so much capacity in our prison service?
Well, I thank the Honourable Member for Household's intervention. I think, as Madam Deputy Speaker indicated, that is an important point and one which I'm sure the House will have an opportunity to consider on another occasion, but I thank him for raising it this morning. Let me turn now, if I may, Madam Deputy Speaker, to Amendment number 4, which would state that the defendant can be a man or a woman. I would like to take the opportunity to echo my right honourable friend in confirming clearly that the defendant for this offence could be a man or a woman, and indeed the victim could be a man or a woman, because, as we've said, this legislation makes no distinction between men or women. We don't, in legislation, generally set out the permitted genders of potential perpetrators or those that might be guilty. I think, generally speaking, almost every, perhaps not quite every, but almost every offence is capable of being committed by either a man or a woman. We don't, generally speaking, need to say so on the face of the bill, and I don't think we need to say so here either, but I'm happy to make clear from the dispatch box that it is our intention, obviously, as with almost every piece of legislation, that either a man or a woman could be guilty of committing this offence. And the Member for Christchurch, the Honourable Member for Christchurch, is quite right to raise this issue and seek this clarification, which I'm happy to give. Let me finally, Madam Deputy Speaker, turn to Amendment 9, requiring the bill to come into force on August the 1st of this year. I completely share the Honourable Member for Christchurch and the Honourable Member for Walthamstow's desire to get this bill activated quickly. It sometimes, if I'm speaking candidly, it sometimes frustrates me as a minister that it takes longer to get things done than perhaps it ought to. So I do share the sentiment expressed. There is, as the Right Honourable Member for Tunbridge Wells said earlier, some uncertainty in the timing through the passage in the House of the bill through the House of Lords. Obviously, their lordships in the other place regulate their own business, and we can't be certain about how their lordships may seek to dispose of this legislation. There is also the question around the guidance that we've discussed already, and the desire to make sure or the suggestion that we publish a draft and people then comment upon that, which will take a little bit of time. I hope it is a few months, but I don't want to create a tripwire that we inadvertently stumble over. So I would like to proceed, or suggest to the House that we proceed, as is ordinarily the case in primary legislation, with commencement, or often the case with a commencement via a statutory instrument, but with the undertaking from the government's point of view, the firm undertaking given here today, that we will seek to do this as soon as possible, because this bill clearly commands in principle very widespread support across the House, and for the sake of protecting women and men, it's important that we get this onto the statute books and operational and effective as quickly as we possibly can. Thank you.
The question is that new clause 1 be read a second time. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it, the ayes have it. The question is that new clause 1 be added to the bill. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it, the ayes have it. Amendment 1, Greg Clark to move formally.
Madam Deputy Speaker.
The question is that the amendment be made. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it, the ayes have it. Consideration completed. Third reading what day?
Now.
The question is that the bill be now read. Greg Clark to move third reading.
Thank you very much indeed, Madam Deputy. We're taking the honourable gentleman's injunctions to progress with dispatch even further than has precedent. Madam Deputy, I beg to move that the bill be now read for a third time. I'm very grateful, I should say, for the debates that we've had in committee and in the House this morning. The amendments that have been accepted by the House this morning, I think, reflect a substantial debate we had in committee, and I'm grateful to my honourable friend for his amendments, which have afforded us the opportunity to clarify some important aspects of the bill and to have some commitments made from the dispatch books, which will be useful to us if, as I hope, the bill continues to make progress. We've taken some time this morning, and I'm conscious that other colleagues have other bills that they are anxious to progress, and if they are to be properly scrutinised, it requires me to be brief. If the House decides to give this bill a third reading today, it will be an historic day. For the first time in our history, deliberately harassing, following, shouting, degrading words at, making obscene gestures at women and girls in public places, and yes, on occasion, men and boys in public places, because of their sex, with the intention, the deliberate intention to cause them alarm or distress, will be a specific offence, and a serious one at that. The astonishing thing is that it hasn't been so until now, many years after it was made an aggravated offence to harass someone in public on the grounds of their race, their religion, or their sexuality, for example. Indeed, women, and it is mostly women, but the bill does apply to men, have had to alter the way that they live their lives, to walk home using different routes, to arrange to be accompanied rather than to walk alone, to have or to pretend to have conversations on a mobile phone whilst walking alone, to hold keys clenched in their fists, in their hands, as a safeguard. And indeed, so prevalent is this that in visiting a sixth form of one of my local schools a few weeks ago, young men and women there of 17 and 18, I asked how many people in the class of students typically walked home with the keys in their hands. Instantly, without conferring, every young woman in the class put their hand up. Not a single young man did, and they expressed some mystification that this happened at all. Such are the changes and accommodations that sometimes subconsciously have been made because of the potential and the reality of harassment in public. Our streets belong to women just as much as they belong to men. Women should be able to use our streets as confidently and safely as men do, free from abuse, free from humiliation, free from violence, physical or verbal. This bill makes a specific but important step. Harassing women in the street, or men and boys if it applies to them, with the intention to degrade or to terrify them, isn't normal, it isn't natural, it isn't just the way of the world. It's a crime, and it's a serious one at that. This bill will address that anomaly, will move our legislation forward, and I commend it to the House.
The question is that the bill be now read the third time. Stella Creasy.
Thank you, Madam Deputy Speaker. This bill has been a long time in gestation. It reflects years and years of campaigning about a very simple concept that the member for Tunbridge Wells has articulated very clearly there, and the surprise that those who are not affected by it feel when they realise it and see it. Misogyny is driving crimes against women and girls. A very simple statement, but a very clear recognition in this legislation for the first time ever that women are being targeted simply because they are women. That young girls in our society walk with their keys, get asked, well, what were you wearing? Told not to get on buses at a certain time of night, to be frightened, to be wary, in a way that young men don't. Now, I want to address head-on the point made by the member for Christchurch, because I agree with him. We have got to stand up for our young men. We've got to stand up for the bulk of young men who know when they see that and when they realise what is happening to their sisters, to their mums, to their friends in school, their aunties, their cousins, how awful it must be that 51% of our society does not have the same freedom to go about their daily business. Those young men deserve better than the idea that somehow this kind of behaviour is inevitable, that boys will be boys. So in passing this legislation today, we are standing up not just literally because this legislation does cover both men and women equally, but also for that quiet majority of young men and older men who recognise this behaviour is completely unacceptable, that it is criminal, and that for too long nothing has been done about it. And I know the member from Christchurch will be somebody who cares very much about the actual evidence. So let me just give him the detail, because where those police forces have been treating crimes that are motivated by sex or presumed sex seriously and recording that data, the story they tell is very compelling for why this legislation matters. 12 out of 43 police forces in England and Wales now use this policy. The Crime Survey of England and Wales found there were 67,000 reports of hate crime based on gender between March 2015 and 2018. 57,000 of those were targeted at women. The police forces started off in Nottinghamshire under the leadership of Sue Fish, and I hope we can all in this House pay tribute to Sue Fish and the tremendous work she's done in recognising the benefits to policing of taking this approach, show very clearly the difference. In that same time period, Nottinghamshire Police received 269 reports of misogyny. 125 of those were classed as hate crime, and 144 were classed as non-crime incidences. Of the 265 misogyny hate crime victims, 243 were female. The same pattern in Avon and Somerset, where just over 90% of the victims were female. But men did come forward too, so we know that men will be able to use this legislation. My point in raising this is not to say that somehow it does not matter that young men might experience sex-based harassment. It's to recognise that at the moment in our society, it is women who are paying the price for our failure to understand how misogyny has driven crimes against them, and to recognise that within the law. And what this law will do, because of that imbalance, is correct that and bring us that opportunity, not just to record that data, but finally acknowledge that in the courts. And in doing so, stand up for all those young men who do not want to see this behaviour, who do recognise that it is abuse and harassment, who do recognise that their sisters, their mothers, their aunts, their cousins, their friends at school deserve the same freedoms to go about their daily business as they do. This legislation, this concept of recognising equally, as we do with other protected characteristics, that there are those out there who perpetrate crimes because of their hatred and their anger towards somebody who is because of their sex or their presumed sex. It's about equality of emancipation. And I say to the member for Christchurch, who I know will be deeply concerned, as I was, by the reports of sexual harassment amongst his own police force in Dorset, one of the reasons why many of us have campaigned for this legislation and campaigned for this recognition is the evidence that we've had from the police forces that are doing it of just how transformative it is. Because let's be very clear, we're not talking about new forms of crime, but we are talking about changing a culture in which women coming forward to report crime have been told, well, that's just life, we couldn't really find this person. Not everybody who follows a woman down a road shouting abuse, suggesting that they might want to touch them in various sorts of ways and somehow that is an appropriate way to introduce yourself to them, becomes a rapist or a sexual abuser. But many of those who are rapists and sexual abusers do start with this sort of behaviour. This kind of data that this legislation will allow us to gather helps us detect and prevent crimes. It helps us to change the culture within policing. And in this week of all weeks, we know how important that will be to the safety of everybody in our constituencies. I share with the member for Christchurch that deep concern about the role models our young men have. I look on with horror at the material that Andrew Tate has promoted. I look on horror the things that you can find online that we know our young men are consuming. But I have great faith in the young men of this country. They don't need to be cosseted or nannied. They need us to stand up for them and their ability to be good allies, to be good brothers, good fathers, good friends, good work colleagues, that they are not likely to behave in these ways. So those who do need to feel the force of the law, and the law needs to be on the side of those victims in recognising that behaviour in the way that we do with other forms of hate crime. By passing this legislation, we are sending a powerful message to our young men that they do deserve better than that caricature of boys will be boys, that they do deserve better than the idea that they somehow couldn't help themselves, because we know that they can, and we know that it's as much about our young men and the message we send them as it is our young women and their freedoms that we are fighting for today in this legislation. And that is why I welcome the fact that this has been done in a cross-party basis. It's why I pay tribute to Citizens UK and Our Streets Now and the Fawcett Society for the work that they have done to make the argument that we shouldn't minimise harassment in public. We should recognise it, treat it equally, and prosecute those who behave in those ways. And I suspect across the House there is a common agreement at how much this debate is changing. We are all of a certain age. We remember things that were on television when we were younger that now we know would not be acceptable. I see obviously a gentleman opposite is shaking his head, and I'm sure afterwards we can compare notes on just how awful our 90s fashion was. But we remember things that were on television and cultural ideas about race and ethnicity that now we would recognise are inappropriate and indeed create a culture in which racial hatred and abuse is encouraged. We hope in time, by targeting people on the basis of their sex or their presumed sex, will have the same effect, that we can challenge those myths and challenge those expectations and challenge that behaviour. But we cannot do that if the law is not on the side of those women who haven't come forward to date, the 80% of women who experience street-based harassment who don't report it. This legislation will change it. It will also support those young men, and it will also support our society to be the better version of itself. I hope members here will support this legislation. This is the start of a process, and I hope the Minister will talk about the training that will be given to the police and the CPS to make sure that this legislation is effective. But let's have no more minimisation, no more shaking our heads and saying it's just the way of the world, teaching young women to be frightened, to go on self-defence courses, to maybe travel with their friends, to carry those keys, any more than we say to young men, well, try not to do it again. Let's change that culture, let's change the law, and let's make this a society where everybody is just free to live their lives in peace, because I'll wager, left or right, that is an ambition we can all get behind.
Jackie Doyle-Price.
Madam Deputy Speaker, I'll be very brief this morning, but I couldn't let this legislation pass without passing comment, particularly as the Honourable Lady's just referred to, in the week that we've seen the Casey review, which actually, again, reminds all of us just how everyday and experienced sexual harassment is for so many women and girls. And I'm really grateful to my right honourable friend for the fact that he's taken up this cause, because in the 13 years I've been here, we've talked a lot about these things, we've talked a lot about violence against women and girls, but it hasn't got much beyond words when it actually comes to concrete action. There's been much resistance to this measure because of the additional pressures it might bring to the police. And in resisting this measure, this place was sending a message out to women and girls that this was their lot. It was normalising that behaviour. And what the Casey review actually shows is that in normalising that behaviour in society, we give a green light to that behaviour within our police services, who are exactly the people who should be keeping us safe. So this legislation for me marks a real turning point, and it marks a real turning point that actually at last we are sending a message that actually, no, we are not going to put up with this. This is not acceptable behaviour. It should not be acceptable behaviour for anyone to be experiencing harassment, and nobody should think that they can get away with it. Nobody should be abusing their power and making people feel uncomfortable and distressed just because they can. So I am hugely grateful to my right honourable friend for this piece of legislation. Really grateful that the government have embraced this and give it support. I think it's a real, it's a rare moment of unity when we're all on the same side on this. And for women, I hope that this marks just the beginning of many more measures that really give us the opportunity to enjoy participating in society without having to put up with this intimidation day in, day out.
Peter Gibson.
Deputy Speaker, it's a pleasure to be called to speak in this debate, and I once again congratulate my right honourable friend, the member for Tunbridge Wells, on bringing forward this important and hugely welcome bill which will better protect all of our constituents. As I outlined in my second reading speech in respect of this bill, we have a long heritage of protective legislation brought by Conservative governments. The Children's Act, the Protection from Harassment Act, the Protection of Freedoms Act, the Modern Slavery Act, the Domestic Abuse Act, and even my own private hire and taxi legislation, or Sharn's Law. Add to this the range of laws my right honourable friend's bill, which we are debating today. I also sincerely look forward to seeing very soon the draft legislation on banning conversion practices as promised by the government, which will add further to these range of protections. Madam Deputy Speaker, I appreciate that time is short today, so I will conclude by congratulating my right honourable friend for bringing this bill forward for its third reading, and I'm happy to give it my full support.
Louis French.
Thank you, Madam Deputy Speaker, and also be brief given the time limits today. And I rise to support this bill to provide greater protection from sex-based harassment, and I also thank the Honourable Member for Tunbridge Wells for all of his great work and all those campaigners out there that have campaigned so hard. But in doing so, and in this brief time that I've got today, can I please urge the Minister again to review the Metropolitan Police's tri-borough policing model, which was highlighted in Baroness Casey's review, which highlighted a number of issues this week. But in particular, in relevance to this bill, it highlighted that 50% more sexual offences occur in the South East BCU area, which includes my home of Bexley, compared to that of the Central North BCU, which includes the likes of Camden and Islington. Yet the resourcing model, as Baroness Casey highlights, is the same for both BCUs, under this one-size-fits-all policing model which was introduced by the Mayor of London. This is not right. And alongside the Mayor's disastrous ULEZ plans, which will impact many women travelling home at night and their safety, can I please urge the Minister again to look into this matter of the tri-borough policing model. Thank you.
Barry Sherman.
Madam Deputy Speaker, I realised very briefly to congratulate the Honourable Gentleman on introducing this bill, and I wanted to be a man on this side supporting from the back benches, because we have some very able women who've led this campaign on this side, and I didn't want to be dismissed. Because I have a vested interest, Madam Deputy Speaker. I have daughters, Lucy, Lucy, Madeline, Verity. I have granddaughters, Megan, Lola, Gwen, Elodie, Rosa and Arwen. They're all girls, and I want them to grow up in a world where this abuse no longer exists.
Elaine Saxby.
Thank you, Madam Deputy Speaker. I warmly welcome this bill from my right honourable friend, the member for Tunbridge Wells. Too many women, and even more concerningly, many girls, have experienced a form of sex-based harassment in public places. The government's own call for evidence ahead of our Violence Against Women and Girls strategy received 180,000 responses, showing the depth and breadth of feeling amongst British women on their safety and exposure to harassment when they are just going about their daily lives. As part of this strategy, Barnstaple in my North Devon constituency has received £348,000 of Safer Street funding to tackle violence against women and girls. I know my Police and Crime Commissioner and local force have been tackling these crimes which act as barriers to women and girls enjoying their local community. I just wanted to take the opportunity to thank my right honourable friend for his work and the opportunity to place on the record my support for this important bill.
Dr Kieran Mullen.
Thank you, Madam Deputy Speaker. I'll also speak briefly and begin by paying tribute to my right honourable friend for securing the passage of this bill, and I think it's been great to hear it warmly supported in the House today. And I rise primarily to pay tribute actually to a group of girls who really helped me understand this issue. Sandbach High School is not in my constituency, it's in constituent of the member for Congleton, but she very kindly agreed for me to visit it because so many of my constituents go to school there. And I had a session, it's a girls' school, with a group of girls who really put across to me how much of a frequent issue it was for them, even at this point in their lives, and how commonplace it was for them to experience that harassment. And also to pay tribute to a charity in Crewe called Motherwell, founded by Kate Blakemore, because I think what we discussed today is recognising this sits within a bigger picture of how we think and treat women and girls in society. And Motherwell is a women and girls charity dedicated to empowering women in all sorts of different ways, including looking at issues of their own safety. And that organisation, that group of girls really helped me understand this issue, and I'm been pleased to be here today to pay tribute to them and pay tribute to my honourable friend in supporting this bill.
Shadow Secretary of State, Annalise Dodds.
Thank you, Madam Deputy Speaker. I made my thanks previously to those who've done such an excellent job at bringing this legislation to the House, and so I will be very brief, but I wanted to underline, I think, an incredibly important point that was made by a number of speakers. This bill will be positive for everyone. And obviously the evidence for this has already been set out, including a moment ago by the Right Honourable Member for Tunbridge Wells. When we look at the evidence around the impact of this kind of behaviour, especially on girls, I know all of us in this House are incredibly concerned. Girl Guiding found that a third of girls aged 17 and 18 first experienced harassment at the age of 11. Now, it will be good for girls and for women and for boys and men to be clear that the atrocious behaviour of a minority is something that is truly rejected by the majority. Therefore, this is important legislation. Now, while it's very good this bill has government support, I would say it's a shame that some of these very important issues do seem to, quite often at the moment, be relegated to private members' bills. It is 2 years since the Violence Against Women and Girls strategy was launched, and we haven't seen enough progress. We do need to see more. Yes, this bill is positive, but we also need to see misogyny being made a hate crime. We need to see specialist rape courts across the country. We need to see domestic abuse specialists in every 999 room, and we ultimately need to see a cross-government approach. Because while it's absolutely right that we focused in this bill on criminal justice and policing matters, the solution is going to be found more widely as well in our schools, hospitals and workplaces, and not delivering that solution will fail women and girls. Thank you, Madam Deputy Speaker.
Minister Crisfield.
Thank you, Madam Deputy Speaker. I'll be extremely brief, as I know there are many other members wanting to bring bills forward today, and other members have made excellent contributions. Look, I'd like to just quickly congratulate again the Right Member for Tunbridge Wells for bringing forward this legislation, for the work that many members have done on this, particularly the member for Walthamstow, the member, of course, for Thurrock as well, and many others. It's important that this is only one part of a wider piece of work to protect women and girls in particular. Of course, this is a government that brought forward legislation on forced marriage, on stalking, on upskirting, making sure that serious sexual offenders spend more of their sentence in prison. We've brought forward the Domestic Abuse Act, introduced the Domestic Abuse Commissioner, and legislated on female genital mutilation. There is, of course, a lot more work to do, and I look forward to working with colleagues in government and colleagues across the House to make further progress.
With the leave of the House, I call Greg Clark to wind up.
Thank you very much indeed, Madam Deputy Speaker. I'll be very brief and just want to add my thanks to all of those who have been aiding the passage of the bill so far, and to start with thanking my constituents who over the years have shared with me their experiences and have encouraged me to bring forward this legislation, supported by campaigning groups right across the country. In turning those intentions into prospective legislation, one requires advice and support. And I'm very grateful to officials in the Home Office and ministers from the previous Home Secretary, the Right Honourable Member for Whittam, to the current Home Secretary and her ministerial team. The member for Derby Dales, who has seen this bill through its previous stages, has been indisposed today. I'd want to put on record my thanks to her and my thanks to my right honourable friend, the member for Croydon South, for his very able picking up of the brief today and responding to the report stage of the bill. We're very grateful to him for that. Can I also thank the excellent clerks of the House, in particular, if I may single out the clerk responsible for private members' bills, Anne-Marie Griffiths, who does a tremendous job, supported by her very able colleagues. We're very grateful for the advice that she's given. And finally, can I thank the no less able whip that is responsible for Siri. Whips on both sides, I should say, but in particular the member for Castle Point, who has developed a particular reputation for sensing the mood of the House and being able to guide and bring us a House that sometimes can be a forum for contention. My honourable friend has a great skill in being able to bring us together on occasions like this. And so, having put on record my thanks, can I commend this bill to the House?
Well, I thank the right honourable gentleman. Anne-Marie Griffiths was here earlier. She will be back, but we will ensure that she is aware of your kind words. The question is that the bill be now read the third time. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it.